Good afternoon, everyone. Welcome to HHQ webinar on legal aspects of share sale agreement. So we are glad to have many esteemed attendees with us today. So my name is Aini Ajira, Pupil Chambers of Halim Hong and Quek, and I will be the moderator for today's session. So before we kickstart this session, please be informed that all participants will be muted. If there are any questions, please type in the chat box and we will discuss them during the Q&A session later. So now please allow me to introduce our speaker, Adrian Koh. So Adrian's areas of expertise include mergers and acquisitions. So he has also been actively involved in transactions across a wide range of industries, including manufacturing, technology, retail, energy and infrastructure, as well as financial services. So please join me to welcome our speaker, Adrian. So Adrian, please.
Hi everybody. So today I'll be talking about the legal aspect of a share sale and purchase agreement. So what I'm going to focus today is on the salient terms of a share sale and purchase agreement. So to simplify this, I will call it SPA, because generally SPA is being drafted by the purchaser. Okay. Yeah, so typically in a share sale and purchase transaction, these are the process that are involved. So you generally, first of all, there's a letter of intent of a term sheet or MOU, and then parties will sign that. After signing, they will proceed with DD. After DD, completion of DD, then parties will proceed with drafting and negotiating SPA. Please do note that sometimes DD and negotiating the SPA can be done concurrently. So this is quite common as well. Then after negotiating a SPA, parties will then execute and then proceed for CPs and completion. So I just want to highlight a couple of things when you are drafting SPA, because this session is about the SPA, right? You want to understand what kind of transactions that you are being involved in. Is it a bidding scenario? So a bidding scenario, there are two kinds of bidding scenario. One is where the vendor prepares the SPA, and you as a purchaser, you as a potential bidder cannot amend the SPA. So purchase consideration is based on the current draft that is being provided by the vendor. That's number one. The other kind of bidding is that the vendor will provide a draft SPA, and then you do the markup, submit your bid document, your process letter, and your markup SPA to the vendor, and the vendor will decide at the end who to accept. The other scenario is where the vendor don't prepare a SPA, so you submit your process letter together with your draft SPA. So I think that is less common. The second route is actually more common nowadays. The second scenario is a normal sale where you have a buyer and a seller on a friendly basis. So that is the normal, I think generally in Malaysia, I think that is a general practice right now. The third kind of transaction is where there's a forced sale. So for example, it's pursuant to a put call option where you are forced to sell your shares. So situation in a bidding, in a normal sale, and in a forced sale are slightly different. So you may want to account your drafting to take into account these scenarios. Okay, next. So generally in the SPA, the SPA will contain recitals, agreement to sell, consideration, CPs, completion, pre-completion covenant, reps and warranty, remedies for breach, and certain boilerplate clauses like governing clause, time is essence, notice. So in this talk, I will focus on number 1 to number 8. I think boilerplate clauses are pretty standard, so we will go into details now. Okay, recital. So what is a recital? Recital is preamble in an agreement in the SPA to set out the background facts of this transaction. So typically in the SPA, you will have like who are the owners. The current vendor is the owner, free from encumbrance, and they are intending to sell, how much, And the share cap is how much generally in the SBA, it's quite a short one, unless you have transaction before the SBA. So for example, restructuring and all this, so you may want to include that. Just want to highlight that recitals do not form a part of the contract and it's not an operative clause of the provision. So there's a federal court case which held that in the event that the terms and conditions in the SBA is ambiguous, what will happen to the recital is that the recital will merely aid the interpretation, but it will not overrule the terms and conditions. So the terms and conditions of the contract must be looked as a whole. Okay, so the next one would be agreement to buy and sell. So what you agree to buy as the purchaser should generally be free from encumbrance, as either as at completion or as at signing. And what you will buy is together with the shares itself, you will also buy the rights, benefit, entitlement, such as dividend, voting rights, which will be accrued to the purchaser on completion date. Okay, so the next clause we are going to discuss is consideration, how you want to pay for your purchase. So generally, there are two types of consideration. One, you pay your consideration via cash. The other way is non-cash. So we will now zoom into the cash portion. So there are two kinds of cash consideration. One is either you pay in full. The other is you pay in different tranches. So if you make full payment, generally purchasers will only want to pay once they get their shares. So that will happen on completion date. If you do make full payment before completion date, there's always a risk that what if the vendor don't sell it to you? So you must make sure that in the event you pay a full consideration before completion date, make sure that in your SBA you provide for a refund mechanism in order to refund the whole purchase consideration in the event completion does not happen. So what you can do is, other than getting drafting direct indemnity or refund clauses in the SBA, you also may consider third-party guarantee, either a director's guarantee or a bank guarantee, depending on the circumstances and the negotiating power of the parties. Okay. In terms of payment in tranches, so payment in tranches, you can either pay a deposit and the balance consideration at completion date, or you can pay deposit, something in the middle and on completion date, or more, which is post-completion date, you make payment as well. So this really depends on your bargaining power and commercial agreement between parties. Okay, so when you're drafting deposits, right, you should also take into consideration whether the deposit paid by the purchaser, either on the signing of the term sheet or on signing of the agreement, whether it's forfeitable or not. Just want to go back on the previous slide. So the letter of intent and term sheet, these are usually more for non-bidding situation. In the bid situation, they will give you generally a offer document to describe, what is our company, the target code, some brief details about the target code and the offering letter. So in a bidding situation, you won't see a LOI or a term sheet. Okay, so we go back to this. Okay. Say if it's a refundable deposit, you want to consider whether there is an escrow arrangement or not. So whether you want to pay directly to the vendor or you want to pay to an escrow agent. If you wish to engage an escrow agent, then you need to set up clearly. What I would recommend is an escrow agreement to govern how you want to refund the money in terms of the regulation between the vendor, the purchaser, and the escrow agent as to when the escrow agent can release the money. Okay, balance consideration. In certain circumstances that I have done, purchaser are willing to pay the full sum one off, but they don't want to pay to the vendor, so they pay to an escrow agent. So that you may consider that rather than paying directly to the vendor, and the escrow agent will release the whole sum only on completion date or any other period as agreed. Okay. The other scenario where you have the balance consideration paid separately is when you have an adjustment to the consideration. So for this, right, in this kind of scenarios, you will have, for example, the vendors providing a profit guarantee. So as at completion, I guarantee certain profit or certain NTAs to be achieved. NTA is a net tangible asset to be achieved. So the valuation will be redone again nearer to completion. That's why you have to split the purchase consideration. Okay. Yeah. So the next one would be payment of consideration via non-cash. So via non-cash, you can have via shares. So shares of a private company. In the case of a share, you'll be doing a share swap. And the next one would be shares of a listed co. So shares of a listed company, you will typically it would be allotment of new shares via, for example, private placement or or from existing market. So if you are drafting an SBA that the consideration is being paid via listed shares, right? You have to take into account whether there are additional requirements imposed by BOSA or SC for the sale of the share. For example, whether they need a shareholders resolution to approve the private placement, for example, or the issuance of new shares, whether there's a BOSA or SC's approval. So that should be factored into your SBA and into your CB period. Okay. Other than shares, you can also pay your consideration via real property, so via land or via house. There are, of course, other non-cash consideration, for example, equipment and so on. But I think more common shares and properties. Okay. So we'll come next to CPs. So what are CPs? CPs are matters to be fulfilled before the SBA becomes unconditional. That means prior to CP being fulfilled or waived, parties do not have the obligation to complete. So once you have fulfilled CPs, then parties now must proceed to completion. Okay, so what are the general CPs in SBA? It will be approval from regulatory bodies. So it would be, for example, in the manufacturing scenario, would be MITI or MIDA. In the financial services industry, you may want to look whether you need SC or BNM's approval, or sometimes in some land companies with a lot of land, there may be some approval from the land office. So you want to consider whether as a purchaser lawyer, this is the most important part of the transaction, because without this, if you miss out, then there will be an onerous obligation on you after that. And it may impact valuation of the consideration as well. Okay, so the other one will be more common, will be approval of board of directors and shareholders. Approval of banks and financial advisors will be only applicable in the event you have borrowing. Generally, financial agreements and arrangement would require approval of the bank if there is a change in control. I think I have seen quite a lot of financial agreements where even a slight change will also require the approval, i.e. change in shareholding structure and control. Okay. The next one would be approval of any third parties. So for example, supplier, customer. So generally for this, what we would recommend is that approvals are, of course, we should get approval from all supplier and customers who have such provision in the relevant contract. But we would generally think that if it's only material, so material customer or material supplier, you should get consent first. The rest can be done later. So depending on how you want to do it, you can split some on completion and some on CP, but material definitely as a CP. Okay. If your acquisition is less than 100%, so there's other shareholders as well, there may be a need for you to include a SHA or a put call option agreement as part of the CP. But I think generally from a practical perspective, if you are acting for the vendor, if you are acting for the purchaser, you would want to sign all these ancillary documents on signing of this SPA. So you don't want to leave any changes or any material changes in the ancillary documents. Okay, so you know upfront what you're signing or you're signing. So CP for the purchaser, CP clauses, just let me run through this. So in the SPA, you should also include, who is responsible for what. I think certain agreement that I've seen is not very clear as to who is responsible to what for what. So it's better we set out. CP period. So this CP period really depends on what kind of transaction that you are doing. So certain CP can be on the same day as the completion date, i.e. There's only resolution, so you can pre-prepare. Certain CP can drag up to 1 year because they are pending regulatory approval. Okay. The next would be what will happen if the CP is unfulfilled during the agreed time. So you can either extend the time. Usually people build in this clause into the SPA, and depending on the nature of transaction to see whether the period of extension. So as a DD lawyer, you must really understand the business of the vendor, the business of the target code to actually estimate how long this extension would be. The other way, the easy way is to, of course, the purchaser or the vendor where relevant waive the CP. Or if parties don't agree, they can terminate the CP then. Okay, and the next one that we usually have is who will bear the cost of satisfying the CPs. Generally, it would be each party will bear its own. Do note that some CPs are definitely more expensive than the rest because a lot of administrative costs incurred. I just wanted to come back to this. So if you're doing if you're doing a transaction where the vendor is supposed to undertake certain internal restructuring, so that should be included in as well as a CP. So because you don't want to buy something that's not presented and represented to you. Okay, so the next one would be completion. So completion generally in SPA would be a completion date is where the date of the completion of the sale and purchase of the shares. So a simple direct SPA would be completion will happen on the day of the SPA, the date of execution of the SPA. So in this instance, either CP is the same day as completion date or there's no CP at all. The next would be a date where the CP period expired. Okay, so on that day, you have to pay money. The purchaser have to pay money. The other kind is where there are certain X date from the end of the CP period. So generally, this number 3 is to accommodate purchaser to prepare the money. So especially this, right, would be relevant for overseas buyers because they need some time to transmit the money, remit the money into Malaysia. I just want to highlight something when you're drafting the payment clause, right? In certain circumstances, you must be clear when it's counted as purchase consideration being received. So if you are acting for the vendor, you would prefer to have clauses that money received in your bank account, that only constitute payment is done. If you are acting for the purchaser, you would want to include clauses that once I issue I provide the vendor irrevocable undertaking from the bank that I have already paid. So I instructed my bank to make the payment. That constitute payment of consideration. So depending on your bargaining power, so I think that should be taken into account when you're drafting the SPA. Okay, so what will on completion, what will happen? So on completion, what will happen is that first, the vendor will then provide the purchaser an executed, undated instrument share transfer form. Okay, so then they also provide share certificates, members or board resolution of the target co approving the share transfer, stamping documents. Number 5 is the warranty are true, accurate and misleading. This is important because you repeat, warranty is given on signing and warranty is repeated on completion as well. So you need number 5 to make sure that the vendors are aware that their obligation don't extinguish on signing. Okay, number 6 is statutory books and records. So this will be more relevant to your accounting staff and your corporate secretarial staff. Number 7 is bank accounts and revocation of existing authority. So I just want to share with you, I did this transaction where this was an issue, a big issue, because my client, the purchaser, doesn't want the token to be delivered to China because they think it's very dangerous. So the CP period was extended. This was made as a CP, them receiving the token. So if you have this similar scenario, what I would recommend is that we as a lawyer can hold in escrow, and then because now you have internet banking and so those can be retained as a CP, as a completion deliverable, where on completion they have access to such bank account, and then we as a lawyer can hold in escrow. Okay. Last but not least, the vendor's resolution to approve the share transfer. So generally, these are the vendor's obligation. What I would add one more, number 9, is what recommendation you have inserted in the DDR as a purchaser's DD lawyer to provide that on completion certain things should happen. So for example, notification to your customer, notification to regulators, that can be inserted as well. On the vendors, on the purchaser's side, it is less onerous because obviously you're the one buying. So on completion, generally you have purchaser making the full payment or part payment, as well as providing the purchaser's resolution to approve the share transfer. Okay. Now we move to Sba Pre-Compilation Covenant. So once you sign, from signing to completion, you want to make sure that the company is your target co is being run as it is basis. As when you sign the SPA, you want the company to run as usual. So generally, these 8 covenants are usually imposed on the vendor to ensure that the companies are being run as such. So you will not depart from ordinary course of business, your licenses and your contracts you must comply with. You will not incur further borrowing or a further borrowing of X amount. Generally, if you provide for a threshold, you will usually include for what purpose? So for normal daily operation purposes. You will not declare dividends. You will not change share cap and amend the constitution. You will make sure that all insurance policies are being maintained, and you will not dispose asset because you don't want whatever you have done your DD on, those assets are being disposed. Okay, you will not hire new employees exceeding a certain threshold. I think this is more usual in the case of key management because you don't want to suddenly just incur a very big cost. Okay, so I'm going to spend some time today to talk about reps and warranty because I realized that many don't actually focus on reps and warranties. So in the bigger transactions where I have done, generally reps and warranties are done on a separate stream from the from the main body. So one lawyer will be doing the SPA, the main body of the SPA, one lawyer will be doing the warranty, because both these are very bulky and you would want to negotiate both at the same time to save time. Okay, so what is a warranty? Representation and warranty. Warranty is a statement by the vendor as to the quality, the condition, the existence, the value of the asset. So what is a factual thing? And if such warranty is not true, inaccurate or incomplete or misleading, you as a purchaser, you can claim for breach of warranty and you can seek remedy for a breach of warranty. So that's why if you're acting for a purchaser, your warranty must be, you must clearly know that your warranty is consistent with your DD findings. Okay, so what are the type of warranty that are generally in the SPA? That would be number one, a title warranty. So ownership of the shares. These are fundamental warranties. Business warranty. So business warranty will be how many contracts you have, what are the licenses, warrant employers, customers, suppliers, IP, all these are important, all business warranties. So I just want to highlight that certain business warranties are fundamental warranties for certain sectors. So for example, if you are in the manufacturing sector, the existence and validity of your manufacturing license is very important. So that would be a fundamental warranty, for example. Or if you are a design company or you are a company that is IP centric, so your IP warranty is also a fundamental warranty because you're buying this company because of this inducement that they have, the vendors provided. Okay, tax warranties are also very important warranties because certain tax clawback by the authorities, especially if you change from local to foreign owned, tax warranties, you must be very careful. So in a transaction where it's slightly bigger, where you have a financial advisor being involved, make sure that financial advisor have a look at this tax warranty. Okay, because ultimately, sometimes when you change, when you call your authorities, your LHDN or your tax authority on whether there are any penalties or any circumstances that will change in the event the target code is changed, controlled from a local to a foreigner. They will maybe at one time they'll tell you no issue, but few years down the road they may change policy and they'll do a callback. So that's very important. Okay. So the warranty, as I mentioned earlier, is basically a list of factual statement about the company, about the target code. So it's to allocate risk between purchaser and the vendor. So it tells the vendor when a purchaser can claim a breach of warranty and when a purchaser cannot claim for a breach of warranty. So if you don't have a warranty, if you don't have a reps and warranty in your SPA, the only remedy you as a purchaser can rely on is implied warranty. And generally, these are very limited to the title of the shares only. And some material, very, very basic material inducement into the contract. Okay. Okay, so when, as I mentioned earlier, when would a warranty be given? So warranty are generally given on signing and on completion. So as on signing, as and on completion, the warranty must be true, accurate, correct, and not misleading. So during the period from signing to completion, so as you can see, there are two kinds of clauses where there's some way to maneuver. A warranty that is pro-seller will be, so long as during this period, from signing to completion, my warranties are materially true, accurate, and not misleading, then I'm fine. You cannot claim a breach of warranty during this period against me. What is material is a commercial decision. So generally, you can either don't define it, which is very vague, and then you'll come to a dispute, or you can peg this material to a certain event. For example, if a material adverse event happened. So I'm going to talk about the qualifier of MAE slightly later. We'll come back to that. A pro-purchaser clause during signing and completion is that all warranties are true, accurate, and not misleading. And if you have any untrueness or incorrect or misleading in any sense, I can claim a breach of warranty. So it really depends on the negotiating power between the parties. Oops, sorry. Okay, so as I mentioned earlier just now, there's a few qualifiers that you can make when you're negotiating your warranty. Number one is, sometimes when you're doing warranty, you can see it's like, oh, based on the vendor's knowledge. So this knowledge, it really depends on how you draft it. Okay, so generally these are also drafted as a definition in the clause 1, interpretation and definition. So a pro vendor clause will be, if I actually know of this breach, only you can claim. A pro purchaser will be, so long as me as a vendor, I ought to know, so constructive knowledge, then I can claim. So it really depends on negotiating power. A very common clause for warranty qualifier is this MAE clause, material adverse effect. So you can only claim, the purchaser can only claim a breach of warranty if the breach has resulted in an MAE event. So generally there's a percentage to it. So for example, 5% decrease in my revenue, then I can claim for a warranty. Okay. There are also other common warranties qualifiers, for example, reliance only on warranties in the warranty schedule, number one, or anything that is being disclosed as an exception and qualification to the warranty in the DL, disclosure letter. Okay. So the reason why we need to negotiate a warranty is to, as I mentioned earlier, to allocate risk and also to actually encourage parties to come to a consensus, to understand the company better, to know that actually what is the issue with the company and whether this issue will affect purchase consideration or not. Because some things are not disclosed in the DD. Okay. Next would be disclosure letter. So how do you limit recovery of breach of warranty? So number one, you do a DL. So DL are usually signed on signing, and these are exceptions and qualifications to the warranty. So DL, whatever that's being disclosed in the DL will be reported on signing and on completion. So unless otherwise agreed. Okay. This allowing sandbag. So this is actually a pro vendor provision where in the event that the purchaser prior to completion realized that, oh, actually there's a certain breach, but I keep quiet. And then I proceed to completion. And then now after completion, I'm coming out to claim, hey, actually there's a breach of warranty and I'm going to claim against you. So then in these circumstances, the vendor will need to prove that, hey, actually you can't claim a breach of warranty because you have knowledge of it. So these are quite common as well. So it really depends on the negotiating power to see whether you can remove it or not. Okay. The next type would be limiting the claim of the period to claim for breach of warranty. This can be separated into a few kinds. So you need to, when you're drafting SPA, you need to differentiate between two things. Number one is fundamental warranties. So how long you can claim for fundamental warranty. These are usually longer. Number two, normal, general, you would think medium risk warranty. This will be shorter, and as well as ancillary and not important warranty. Either you can clump it under the second category or make it even a shorter period. So for vendors, I would of course prefer, as a vendor, I would prefer a shorter warranty period. I want as short as possible, then my liability is being reduced. But for the vendor, for the purchaser, I would want a longer period so that I can make sure that certain things that can only materialize a much later time I can claim for that. So for example, this transaction that I did, it was a tax warranty. It wasn't that important, but because the tax involved was 25 million, so what happened is that we managed to negotiate up to 7 years, which coincide with the limitation period. So it really depends on what kind of negotiating powers you have. Okay. The next type of mechanism to limit breach of warranty is what kind of breach you can claim for. So generally, I think it's agreeable between the parties that only direct and quantifiable damages can be sought. You cannot claim for either in remote or indirect breach damages. Okay. The next one I would talking about is the threshold to bring a warranty, to bring a claim for breach of warranty. There should be a minimum to bring a claim. There should be a minimum amount, and of this minimum, there should be an aggregate. So for each claim, that total claim that you want to bring against the vendor, you must have a minimum that you can bring. You cannot just bring like a 5 ringgit claim. You must bring at least like 10K, and you must accumulate at least 100K, for example, in order to bring a claim. Okay, so this would manage risk. So manage risk for both the vendor and the purchaser. And the last one, I would say claim period to claim breach warranty, threshold to bring a claim, and cap on the recovery is very important when you're drafting the warranty section. So generally, you want to make a cap on what kind of the limit that you can claim. So generally, I've seen 1%, 2%, 100% of the purchase consideration as well. So it is very rare for breach of warranty to be a form of indemnity provided by the vendor to the purchaser, because this may exceed the purchase consideration. So generally, you want to cap at no more than 100% of the consideration. Depending on your negotiating power and as well as the business transaction value, you may, as a purchaser, you may claim up to 100%, as in particular for fundamental warranties if you are acting for the purchaser. If you're acting for the vendor, you also can argue that in many circumstances, 100% is not very common nowadays, because you have done the DD, you have done the negotiation, we have done the warranty section. So you should take that into consideration, the risk into consideration. So it really depends on who you're acting for. Okay. So generally for remedies for breach of contract, breach of SBA, a purchaser can ask, the vendor can ask, in a vendor case, to forfeit the deposit, or parties can ask for damages, indemnity, or specific performance. So actually, I just wanted to share this clause on indemnity. And I think indemnity, in particular, if you're acting for the purchaser, no, it's not wrong that we will ask for, as a purchaser, ask for under the sun, under the moon kind of indemnity. I want all kind of indemnity in the event of a breach. But also you have to take into consideration, because you are a DD lawyer, you are supposed to know what is the risk. So you will want to highlight in a very difficult scenario, very, very tough and very hard-headed vendor, you could also pursue the route where you limit your warranty to those potential breach that you think is of a significant value. So for example, you think that certain employment contracts, for example, your EPF, your SOCSO is not paid fully, or there's some issue, you want to include that, or certain material contracts you think might not be able to renew, then the sum is very big. So you will want to include indemnity for those. Okay, so yeah, so I think generally if you are acting for the vendor or the purchaser in a friendly deal, you will be as happy as these people when they are listed. Okay, I think that ends my presentation.
So thank you, Adrian, for the enlightening sharing. I'm sure it is very helpful for everyone, especially to those who attend today. So now we have come to a Q&A session for this webinar. So you may post your question in the chat box if you have any question. So I see there are 2 questions for our speaker today. I'll just read it first. First question from Karsunsia. So what are the main differences between warranties and indemnities? Could you please share with us some examples that should be included under warranties and indemnities respectively? And then the second question is from Alicia. So her question is on consideration by way of shares. So say there are 100 shares in a company and A, holding 70 shares, agrees to sell 35 shares in exchange of 5 shares from B, holding the 30 shares. Is there a valid consideration in your opinion, as it is effectively only A who transfers 30 of his or her shares to B? So Adrian, please.
Okay, I'll go to the next question when I see the actual question, because there's a lot of numbers to it. But as to Carsten's question, warranty essentially is a statement of fact as to the condition of the target code. So in the event there's a breach of warranty, then you move to the next stage. As to indemnity, just to elaborate on the warranty as well, not only is a representation from the vendor to the purchaser, it is also a contractual agreement for the sale of the good, for the sale of the shares, promising the purchaser these are the condition of the company. Okay. As to indemnity is a form of relief that you will seek because of a certain occurrence of a breach. Okay. Okay. As to Alicia's question, where can I get her question? Let's see her question. Oh, it's under chat, is it? Oh, examples. Okay, examples of warranty would be. Okay, example, I had the target code has 5 major customer, i.e. 1 HHQ, 2 X, Y, and Z. These are warranties. I promise you that I represent and will warrant to you that as a part of our contractual arrangement in this SBA, there are 5 major customers, and you do acknowledge that. So in the event you breach that, actually there's only 1. The rest are lies, you just anyhow say, or it's a misrepresentation, then you can move to the next stage, which is you claim for the breach of warranty. So then, say on completion, I found out that actually there's only 1 or 2 left. So now I can exercise my power to ask for indemnity. You promise me that, and you represent to me that there are 5. And now there's 2. So my revenue will decrease by how much? So then I can seek for the indemnity in this respect. Okay. Let me see Alicia's question. I have a question. If there are 100 shares, A holding 70 shares. So for Alicia's question, I think it really depends on, it's a commercial decision. I do not foresee any legal prohibition or restriction on this. It's just a commercial decision as to whether the vendor and the purchaser think this is a worthy transaction or not. Because there is no minimum, there is a minimum consideration to be paid. It cannot be 0. I think it can be 0 in limited circumstances, but yeah, there is no restriction on the value of the consideration. Okay, we have one question from Po Yi. Where parties agree to one-off payment for sure. Oh, Po Yi, I think you meant, is there any security that the purchase,
Adrian, just clarify, would impose, actually, I repeated that, is the seller would impose any security or not to secure payment?
Sorry, I don't understand your question, Po Yi.
Where parties have agreed to one-off payment for the share sale agreement, is there any kind of security that the seller would request from the buyer to secure payment?
Is there any security that the seller would impose? Is it?
let's say if it is by tranches, at least there's a deposit, right? If the buyer breaches, then they can at least forfeit the deposit.
I think
But if
for one-off
one-off
payment,
pay,
right, the seller
yeah.
will be quite happy to receive everything at one go on completion date, or even better, some before completion date. But in terms of like any security that the purchaser would impose on the seller, if this is the question you are asking, it's very hard for the purchaser to impose any additional terms and conditions on how the vendor used the money after the money has been remitted to the vendor. It's very hard. I have not seen it based on my limited experience. But if you will want to limit how the seller used your money that's being paid, right? I.e., generally this kind of mechanism would be in relation to monies and consideration being paid before completion date, is that you pay to an escrow agent, and the vendor and the purchaser would agree on how and when the money can be dispersed from the escrow agent. Yeah.
Okay, so what would normally be the arrangement? Parties will agree for one-off or tranches?
Each is talking.
Sorry? No,
Oh, sorry.
which is
I didn't hear you because just now I was on mute.
which one is the preferred mode by parties? Do you prefer one-off or prefer payment in tranches?
I think it really depends on, this is a commercial decision. It really depends on how urgent the vendor would want the money ultimately. Some vendors want the money fast, so they would want some deposit. Some vendors are okay, i.e. they are willing to wait until completion. Then usually it's a one-off for this. So it really depends. It really depends on this is a commercial decision and how urgent the vendor would want the money. So for example, like a bidding scenario, right? It's very rare to have a deposit because you invite many bidders to come and bid for your company. So it's less common, but there are certain circumstances where the winning bidder will need to pay a deposit. Or for example, on bidding results. So there may be a scenario where you ask all the bidders to come, and then you show your check, and everyone show their check at the same time. The highest bidder wins. So that check represents the 10% deposit. So then they will take the check as a deposit. Yeah.
Okay. All right. Thanks, Adrian.
Other questions? Okay, since no questions, right? I think I can share one more thing, which is I thought I didn't have time to talk about, which is merger control. Actually, merger control is not implemented in Malaysia yet. I think that my CC has indicated my CC has indicated that it intends to push for legislation to control merger merger. I think what happened especially is the Grab Uber deal. So the regulators cannot block the deal, unlike in the US or in the UK, where they can block any potential merger. So if the merger control mechanism do come in place in the future, then your CP period have to take into account that, because potentially your deal may be blocked by my CC, and you would want to include mechanisms to resolve this. Yeah. So if you are, for example, if you're acting for Uber and Grab, you want to include SBA mechanisms in the event my CC come and block your this transaction. Okay. Yeah, so just to share more, I have read this in terms of other jurisdictions, how they do this is that not only do they take into account of timeline, so they factor in MyCC's approval period as a CP. They also will factor in purchase consideration to take into account of that risk that MyCC will not approve.
Okay.
Yeah, let me mute this.
Okay, I think that's all from our speaker. Okay, so before we end this session, kindly be informed that an evaluation form will be sent to you via email, and we look forward to your feedback on our today's webinar. So we greatly appreciate your feedback to be submitted latest by 12 p.m. tomorrow. So I believe that's all the time that we have today, and this marks the end of our webinar. So thank you very much for joining us, and stay safe.